Good day, ladies and gentlemen, welcome back to another What If video, this being our last video for 2022. In today's video, I will discuss a scenario where an employee raises cultural beliefs and practices as a defense in his hearing. And the matter I will be unpacking is the case of Toyota South Africa Motors versus NUMSA on behalf of Mr. Njilo. Now, in terms of the facts of the case, Toyota has a written leave policy which provides inter alia for compassionate leave in respect of the death of immediate family, and this is defined as one's husband, your wife, your grandparents, your father, your mother, your father-in-law, your mother-in-law, your sister, your brother, brother-in-law, sister-in-law, your child, or your grandchildren. The policy further requires an employee to provide a copy of a death certificate of that family member, and in certain cases it could also require an employee to provide an affidavit indicating the relationship between the employee and the deceased person. Now, in this case, the employee was dismissed on a charge of dishonesty, in that during May 2013, July 2014 and Feb 2015, he allegedly provided false information about his relationship to the deceased, which resulted in him receiving compassionate leave payments for which he did not qualify. So his leave forms in 2013 and 2014 reflect the deceased as mother, and the leave form in 2015 reflected the deceased as son. So explained in Western terms and that of the policy, the son was the employee's late brother's son, and the mother's had been his late father's second wife, as well as his aunt. The employee was dismissed and he was unhappy with it, so he took the matter to the CCMA. So the matter went to arbitration, whereupon an award was issued in favor of the employee. Now, the arbitrator accepted the employee's version, which in broad terms was that firstly, he just knew from a colleague that one can apply for leave when a family member dies. Secondly, he had been unaware of the intricacies of the compassionate leave policy, particularly that it did not cover people he regarded in Zulu culture as his immediate family, in other words, his mother and son. He said that in Zulu culture, a man assumes responsibility for his deceased father's wife or wives and the children of his deceased brother. He said that in any event, he had not hidden the relationship between him and the deceased when he approached his Zulu-speaking team leader to apply for leave. Finally, he said that he was traditional and would have used cultural names to describe the relationship. So in summary, the arbitrator found no dishonest intent on the part of Mr. Njilo. The arbitrator further found that in any event, the sanction of dismissal was grossly inappropriate given the unique circumstances of the case, Mr. Njilo's length of service, which was 17 years, as well as his unblemished disciplinary record. The Commissioner also held that there was further no evidence of a genuine breakdown in the trust relationship. Toyota was not happy with this outcome, so they took the matter on review to the Labour Courts. So Toyota challenged the arbitration award on the basis, firstly, that the arbitrator based her award on matters that occurred to her when she was writing the award, but that the parties had no opportunity to address. And these were in respect of her views on isiZulu cultural norms and beliefs. Now, in this regard, the court held that this claim had no merit, as the matter of cultural norms was pertinently raised by the employee during the leading of evidence. Toyota's second ground of review was that they challenged the award on the arbitrator's factual findings regarding the employee's knowledge of the leave policy and his relationship with his nephew. Now, in this regard, the court held that there is no demonstration of a material misdirection by the arbitrator. The court held that Toyota's case that the employee was well informed of its compassionate leave policy was based on the weak premise that he had applied for compassionate leave on numerous times, and a suggestion that he may have seen a copy of the policy on a notice board. So the court said that the leave policy comprises some 35 pages, with compassionate leave situated in an obscure section in smaller writing. Toyota did not prove that the employee was given a copy of the policy or that its contents were properly explained to him. The court said that given the common knowledge that there are cultural differences where it comes to who is viewed as family, one would have thought that the policy on compassionate leave would have been better published and explained. Toyota further challenged the award on the basis of the arbitrator's finding that the sanction was inappropriate. But in the court's view, another arbitrator could have easily found that the sanction of dismissal was unfair, given the position the employee occupied. He was not a senior employee, he was in fact in a lower level position. He had long service, 17 years, and he had an unblemished record. Plus, there was no evidence presented that demonstrated a devious manipulation by the employee to achieve compassionate leave. And as mentioned before, there was also no evidence that objectively the trust relationship was destroyed by the employee's conduct. So the court, ladies and gentlemen, accordingly held that on the totality of the evidence, the arbitrator did not commit any reviewable irregularity in her assessment of the evidence or her conduct of the proceedings, and the court found that the award should stand. So the review application lodged by Toyota was therefore dismissed. Now, ladies and gentlemen, what we learn from this case is that in cases where an employer wants to rely on the intricacies of a policy, specifically a compassionate leave or family responsibility leave policy, the employer must at the very least be able to prove that the employee was aware of such a policy. Now, the outcome of this case certainly does not mean that employees qualify for family responsibility leave when non-immediate family passes or pass away. We know that in terms of the Basic Conditions of Employment Act, employees only qualify for family responsibility leave in the event of the death of the employee's spouse or life partner, the employee's parent, adoptive parent, grandparent, child, adopted child, grandchild, or sibling. However, if you want to charge an employee with dishonesty, the employer must prove that the employee was aware in the first instance that he does not qualify for family responsibility leave if a family member is not covered, or a family member not covered by the policy passes away. Ladies and gentlemen, that brings us to the end of this video. Thank you for your support and for your views and watching our videos throughout the year. Also, thank you for your likes and your comments. I will be back with the next video in the last week of Jan next year, 2023. I wish you a blessed festive season. Please stay safe, and I'll see you next year. Bye-bye.